Hello and welcome to Absolute Trust Talk. This is another streaming version of our podcast here at Absolute Trust Counsel. And I'm here with Madison Gunn, of course. I'm Kirsten Howe. We are the alternating hosts of this episode of this podcast. And so we're very happy to have you here today. And we may have some visits from my furry family because I got them all settled down a few minutes ago and now they're all up and wandering around. So I apologize in advance for that. And we may hear from Madison's dog who's lying at her feet snoring.
Yeah. Might have a snoring chihuahua on our hands.
Okay. But anyway, down to business. There is a lot of misinformation, misunderstanding about guardianships. This is something that we encounter in our practice. It's an important issue in estate planning, and there are always a few things that parents are surprised to learn when we explain guardianship to them. Oftentimes, I uncover that one of the reasons that parents take a long time, they procrastinate, they put off doing an estate plan in the first place, is they have a hard time with that issue of who should be the guardian, because it's not an easy decision and it's a very important one. So today we're going to talk about kind of the basics of guardianship. You know, who needs to name one? How do you pick one? What is the process and what can you do to avoid it? We don't do guardianships in our office. We refer those to our colleagues, but it's so closely related to what we do. And it's just such an important topic that we felt this was an important thing to cover in our podcast. So, all right. So first of all, I think we need to point out that there are two basic types of guardianship. Madison, I'll make you do the heavy lifting. I get to ask the questions. She has to give all the answers. That's what happens when you're the boss.
Yep. I was going to say that's your pay grade. This is my pay grade. So there are two kinds of guardianships. It's very similar to conservatorships. There are other types of probate issues where it is in the probate court. There is of the person, which is like personal. You're choosing how someone's living, how they're being raised. You have custodianship over them or guardianship over them. And there's of the estate, which is always means money. Estate always means money. So there's the idea that if a minor inherits money, they might need, even if their parents are alive, they might still need a legal guardianship for that over them in order of their estate to handle that money. So that's where that would come into play. But if parents pass away, you would need a guardian of the person to raise the child and a guardian of the state, possibly, to manage any funds that were left for that child.
Right. And we're talking about, when we say child,
under
in this
18.
context, we mean under 18. In California, that's the age of majority is 18.
Yeah. If they're under 18, they can't own property. They can't be on a deed to a home. They can't sign a contract. They can't register themselves for school unless somehow they're some legally emancipated minor, which we're not going to get into, but that would be an exception to the rule of under 18.
Right. So even if they're 17 and a half, they legally need a guardian in order to get through life. Okay. So anyone out there who has a child under the age of 18, they need to pick someone who they would like to be the guardian of the person for sure. If something happens to you, your child is going to need a guardian of the person, possibly of the estate, just in case something happens to you and you're not able to be that person. So what about in the case of divorced parents?
Yeah. So if you're divorced, typically your ex-spouse would, or the parent of the other parent of the child would be the one that would take over in theory. But not everything is, the Brady Bunch. And sometimes that person isn't able to take over the care of a child. What if they travel all the time for work? What if there's not an ability for them? You still want to name someone who would be the guardian, because, if something happens to them, or if they're unfit, or they just don't want to or can't, then at least you have a say after you've passed or, become severely incapacitated as to who could raise the child.
Right. But absent some kind of extreme situation, the other parent of the child already is the guardian of the child.
Right. There's no
Absent
paperwork.
absent
Yeah.
having their parental rights taken away from them.
Yeah.
But you still need to, express your wishes.
Yes.
That is good, solid planning. Because just in case, that's what we do. That's what we deal with is well, what if this happens? Always.
Definitely. All the what ifs.
Yeah, that's our favorite question.
Mhm.
What if this? Okay, so what factors, qualities are we considering when we're trying to choose a guardian?
It depends.
Yeah.
If you're handling the guardianship of the person raising the child, obviously it's much more personal in the qualities that you're looking for. You want someone who is gonna that can they raise your child? Do they have 10 kids of their own? Is adding one more nothing, or is it too much? Sometimes people say that. If I have 3 kids, what's 5? But personally I wouldn't say that, but that's people's opinion. Do they have the same morals and values that you do? Do they understand your child? Are you sending your child to live with a stranger just because they're your aunt? Do they have a relationship with your child? There's a lot of it's all personal questions. So it's like the list isn't something we can necessarily populate too detailed because it's going to be very specific to your family. But those are all things. If you raise your children in church and you want that maintained, you should send them to somebody who's going to do that. And we do what we offer for our clients, and a lot of estate planners probably do this as well, is that there is a letter of intent that you can write as a part of your estate plan. We do it for our special needs clients and minor children, so that you could write a letter to the potential guardian saying, this is how my child is. They have night terrors. This is how you fix it. This is, all the little things that only you would know as the parent, that you have the ability to write that in there. It's not a legal document. It's just very helpful.
Yeah. It's why not? It's like doing a brain dump about your child onto a piece of paper.
Yeah.
And just to make it easier for that guardian. Yeah, I think it's the point that you made very important to think about your values, what's important to you. If, as you said, if religion is very important to you, then pick someone who will honor, that aspect of your style of parenting, or it could be anything else. It could be music.
Yeah.
It's very important that our children have music lessons all through their childhood or
Yeah,
whatever.
it could be, oh, you're gonna get up, every day and take them to baseball, and you're gonna do traveling baseball year round, all, sports, that's a big commitment. So if you want someone who you want, that's what your child likes, you want to pick someone who's not going to brush that off,
Right. Yeah. And I guess also, the calculus changes as the children get older. If you've got 2 kids who are in high school, that's maybe a little bit different than toddlers, trying to figure out who would be a good guardian.
And I see a lot, I don't know if you do with our clients, but I see a lot of people who, when their kids have an age gap, they pick the older child to be the guardian of the younger child. And I would say there's nothing wrong with that, but you should have that conversation with the older child first.
Right. Don't spring that on your 19-year-old.
It cannot all be like a Hallmark movie. It's not where they take in all their siblings because something happened to mom. It's a lot harder out there than it is for people on TV.
But it can be a good solution, especially if it's only for a short period of time, and there's the financial ability to not derail the older child's life.
Yeah, and I would say, especially if you have family that's supportive in the area, that's not, if all the family lives in Maryland and your kids live here, that might be difficult. But if you have aunts and uncles that live here that can help support, I think that's great. Or friends, whatever. It doesn't have to be blood. I was trying to reiterate that too.
Yeah. And just as a reminder, there are two different jobs in the, I'm just going to call them orphan child's life. There's the parenting, which is what we just have been talking about, the guardianship of the person. And then there's handling all the money. They can be two different people. They don't have to be the same one person doing all of that. And some, you want to pick someone who's best for each job.
Yeah, and you might even want to pick a non-interested third party to be the
money.
guardian of the estate to handle the money, and then there's no issues of, ill intent or mishandling funds. It's all handled by a fiduciary or a bank, and
Yeah.
they just, you submit your expenses and they pay you back if they're the guardian of the person, or whatever system you set up.
Okay, so a parent, we are saying we want all of our parents to express their wish about who should be the guardian. How do they do that? What is the process for that?
It is just write it down and sign it. It doesn't have to be anything fancy, doesn't have to be notarized, doesn't have to be drafted by an attorney. I used to say stick that on the fridge if you're going out of town. If you don't have something, throw a temporary guardian on there and throw a permanent guardian on there. And that's just because, a temporary guardian, if you don't name somebody and somehow the police are there, you don't want your child to go to family services. You want them to be able to place them with, even if it's just the neighbor, as long as they know the neighbor is not a felon. It's not going to be a problem.
The neighbor can take them until family shows up.
Yeah.
And can deal with it.
Yeah.
Yeah. Yeah. So it's so critically important. Just do it. Even if you haven't gone and set up a formal estate plan, you can do it. You just have to write it down and sign it.
Yep.
And that is an official nomination, but that's not the end of the process. That's just really basically the beginning of the process.
Correct. Yeah. Even if you name somebody and you write it down on a Post-it note, you still have to go in front of a judge. So if somebody's parents pass away and a guardian, you have a temporary one that's actually caring for the child. But in order to get the actual document that says you're legally allowed to register them for school, take them to the doctor, you have to go in front of a judge. So as parents, we're on birth certificates. We don't need any extra paperwork. But if you are not on the birth certificate, you're applying for guardianship, the judge has to issue you what are called letters, which is very similar to probate, conservatorships. It's that particular order from the judge that allows you to be able to do that. So there's a whole process to go through. And if you have a nomination, if somebody's written your name down as the guardian and that was the parent, you get like higher standing in the court. They're going to try and go off of what your wishes are, or what the deceased person's
with the
wishes
parents
are,
wish.
say.
Yeah.
Parents. Yeah.
Yeah. It's not a slam dunk. The judge's job is to do what's in the best interest of the child. But they do lean toward the parents' wishes if they can.
Yeah. It's always better than just picking a random family member. Somebody's put some thought into it.
Right. And it is a judicial procedure. So there, you've got to petition the court. You've got to notify certain family members. There was a hearing. Other people have an opportunity to come forward and object. They'll know that person would be a terrible guardian. I should be the guardian. So
Right.
there is that, possibility. And I find that people are often surprised to hear that somebody could challenge what the parents want, but they could. So it's just something to keep in mind. Okay. So if a child under the age of 18 suddenly has money, for example, they inherit money from someone, or they I don't know, win some, I guess they could win a judgment in a lawsuit or something like that.
Sure.
But that would be probably done through a guardian anyway. But most likely it's going to present in they've inherited some money. Even if they have a living parent or two living parents, we're going to have a guardianship of the estate.
Yes. You can avoid that.
But you can avoid that. That's the part you can avoid. You
Yeah,
can't avoid a
the
minor
guardianship.
child having a guardian of the person, because the minor has to have an adult responsible for them. But planning can get you out of guardianship of the estate.
Yeah.
And
And the
so,
big difference is when you have a guardianship of the estate, you have to report an accounting to the court every year, every 2 years, depending on the jurisdiction. So with the guardianship of the person, they're like, you just have to maintain an address and maintain a current photo in case they go missing. Like those are really the only requirements that the court has for guardianship of the person in terms of maintenance. When it's of the estate, you have to,
yeah,
file an inventory of all the assets. You have to file a first accounting, and then every 2 years you file an accounting after that. And then when they turn 18, you have to file an accounting and then they get everything at 18. The guardianship ends. So
right,
whether you want that for your
right.
child or not,
Yeah.
that's the
So
difference.
it's not ideal. It in many ways that is not a good financial plan for a minor child to we'll just do a guardianship of the estate if that happens. So
Yeah.
the alternative is
To use your trust, use your revocable trust that you set up with your estate plan, that with your attorney, where you nominate those guardians, but also where your trust is set up such that any money you have to go to your children is held in trust. And I don't just mean your cash or your house, but your retirement accounts, your life insurance, your annuities, things like that. Because even under 18, and we've seen it, when you're under 18, if you receive an IRA, and let's say grandma named you as the beneficiary on the IRA, and grandma's taking RMDs or required minimum distributions, those still have to be continued to be taken until that child is 18, and you have to self-direct those. But a minor cannot call the bank and
can't do
say,
that.
give
Mhm.
me my RMD, because they're not old enough to. That's a contractual um, situation that they're not old enough to do. So you would have to have a guardianship for that. So using the trust is a lot easier. You can name the trust. There might be tax implications, but it's going to be much less than having to go through the whole court process for
Right.
that.
So we always recommend that the beneficiary on the IRA or the 401k or whatever it is, when there are minor children involved, it should be the trust rather
Yeah.
than the children themselves. And that's that. So that you mentioning grandparents is like another little wrinkle on that, which is, in your own trust, you want to contemplate the what if. Well, what if one of my children dies before me? Now, suddenly my grandchildren are inheriting something. Have I thought that through carefully enough? Um, you want to make sure that if someone under a certain age is a beneficiary, that the money is held in a trust. You don't want it to say outright to this person who's 7 years old.
Right.
So you got to think all down the line when it comes to minors inheriting money.
Yeah, absolutely.
Okay. All right. So and that point about they inherit, even if you go through the guardianship process at 18, it's over. And that might be too young for them to have a bunch of money. But
Yeah, and if you have a special needs child or anything like that, it's a whole other, well, there's a whole other podcast on that, but those are all things that you have to take into account,
right,
in terms of that.
right. Very good. Okay. So I am going to turn to our questions and see what we have here. Excuse me, those of you who are in the audience, while I scroll back looking for questions. Okay, so question for you, Madison. Is it okay to name a couple as a guardian as opposed to a one individual?
I would say it is okay. I mean, there's no law against that. Um, but you should think about it. So, what happens if they're divorced at the time that you pass away and they are nominated as guardians? should it just be one of them? Is one your sister and the other your brother-in-law? And there might be a natural way of how, who would actually get the guardianship. You can put in there if they're married. You can be as specific and detailed as possible. In fact, you should be as specific and detailed as possible on that guardianship nomination. So it's easy to say, I want, Susie and Tom to be the guardians for my children, provided that they're married. If they're no longer married, then I just want Susie
Just
to be,
Susie.
yeah,
Yeah.
or if they, I want Susie to be guardian, provided that she's still a member of the church that I take my kids to, or whatever the scenario is that you feel most strongly about. Those are things that you should be clear about in
Yeah.
your nomination.
Yeah. Okay. Yeah, you don't want your children to be the subject of a custody battle that's not
Not
even
their parents.
not even your issue. Yeah,
Right.
somebody else's custody battle. Yeah. Okay. So, another question, what can you do to make sure that someone you don't want does not get nominated? How can you make sure of that?
Well,
If you can.
yeah. Well, I mean, don't nominate that person. That's like the
Clearly.
obvious.
Yeah.
I would say, when in doubt, write it down. When in
Mhm.
doubt, say, I absolutely do not want this person to be guardian, and say why.
Yep.
Pretend like you're testifying in court, only you're not alive to be testifying in court. So it's all evidence that can be used in a
Mhm.
court proceeding. I mean, this is not a trial that you're going to typically for a guardianship.
Right.
It's usually not adversarial, but if it does become adversarial, you can still have your voice be heard, as we would
Mhm.
say, beyond the grave.
Yep.
You know.
Yeah. Yeah. Just write it down and be specific. This person would be terrible because
Yeah.
of,
Say why.
they're
Yeah.
on meth, they whatever
Yeah.
it is. Yeah. Okay. Okay. So I'm going to just scroll down. I think there's one more question, but I want to make sure I don't miss any that came in after that. Okay. What about if the person you want to be the guardian doesn't live near where you and your child currently live? Is that a problem?
It's not a problem, but you have to think about that in terms of your child would be uprooted. So what we see a lot of is, especially when those kids are in high school, it's they pick the guardian based on that kid getting to finish high school at that high school. So a lot of times they choose that, or with a caveat that they all move into the house that's in trust for, for them to finish high school. I would be leery of that, where people are surprised to find that family members might challenge you in a guardianship proceeding. So if 90% of the families in California and the one person you name as guardian is in New Jersey, that you might have some opposition taking that child away. Or we've seen quite a bit family who don't live in the country,
Yeah.
which I'm sure poses its own set of problems that I don't even know about. But
Yeah.
if that child holds dual citizenship already, by virtue of being your child, those are all other issues that might be,
Right. Right. And
brought up.
yeah, and like I said in the beginning, we don't practice guardianship, so some of the more nuanced
Yeah.
aspects of who can you name and who is it smart to name in terms of geography, we wouldn't necessarily be the best
It
person to.
also sounds like a jurisdictional nightmare. So like that,
Right.
it just makes things difficult for everybody.
Yeah, if you want to take a California child to live in New Jersey, there's going to be some court process involved in that for sure. Okay, that is the last of our questions. So, Madison, any final words on this?
I would just say, when in doubt, write it down. Write down
Yeah.
all those wishes, all the things about your child, and keep it up to date. You
Right.
do your estate plan when the child is 3. When they're 13,
Different child.
what teddy bear stops a tantrum is going to be a little bit different of an answer when they're 13. So I think that, that is all something that it should be an ongoing thing that you keep up to date. And that would be great. I mean, nothing's going to happen to you, so don't worry about it, but you should have the plan just in the what ifs.
Right. It's extraordinarily unlikely in this day and age that a child would need a guardian, but it does happen. And keeping it up to date is, because you might the person you think would be good for your 3-year-old might not any longer be a good choice when your kid is 13.
Yeah.
So that's another important change you might want to make. Okay. Well, thank you, Madison. You're always a great source of information. And I hope you all got something valuable out of that. And we are very happy to have you here. Those of you who are watching live today, those of you who watch later down the road, same thing. We're happy to have as many viewers as possible. You can always find all of our episodes on absolutetrustcounsel.com. And thanks so much. We look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.